Hello, everyone, and welcome to Uncivil Law. For today's video, we turn our attention to the ongoing issue of illegal immigration, due process, the role of the courts, the role of the president, and how these things all interact. And we turn specifically to Justice Alito, who provided an opinion relating to recent Supreme Court action. So as we discussed in a prior video, the United States Supreme Court refused to intervene with respect to an ongoing issue in one of the lower courts, at least at this time. There is an ongoing issue relating to illegal immigration and also purported a possible class action. The Supreme Court has previously ruled on this issue. It's now back at the lower courts and working its way back through the courts as it does. And essentially what happened was the Supreme Court, and for that matter, the Court of Appeals, was asked to intervene early. And they both kind of said, no, we're not going to intervene early, or at least not at this time. And so Justice Alito has some thoughts on the issue that he'd like to add to the mix, so we're going to go ahead and discuss that. We turn to the opinion of Justice Alito as well as Justice Thomas, who write a dissenting opinion relating to this emergency action in the case of AARP versus Donald Trump on an application for an injunction. So this is not ultimately on the merits. This is just an injunctive relief. Please stop something or please do something in the interim. And the Supreme Court was asked on its emergency docket, and it's like, no, we're not getting involved. And so let's see what they have to say about the issue in dissent on this issue. Shortly after midnight yesterday, and this would be the day before, the court had hastily and prematurely granted unprecedented emergency relief. Well, I'm not sure necessarily that's really true, but okay. Proceeding under the All Writs Act, the court or the government not to remove the putative detainees until this court issues a superseding order. Yeah, they want to make sure that the process goes through. And again, this might be extremely cursory in the end, right? It could just be, the Fifth Circuit reaches a decision and the Supreme Court basically says, yeah, that's cool. But basically they want to keep things in place to give the chance for things to work through. Although the order does not define the putative class, well, it wouldn't. The class action itself defines it. It appears the court means all members of the class the habeas petitioner sought to have certified, namely all non-citizens in custody in the Northern District of Texas who were or who will be subject to the March 25th presidential proclamation entitled Invocation of the Alien Enemies Regarding the Invasion of the United States by Trans de Agura and or its implementation. And although the court does not specify what it means by the government, in terms that it indicates the term is intended to embrace all named defendants, including the president. I mean, yes, that would be logical. So basically the entire executive is implicated by this, which, okay. The court did this all even though it's not clear the court has jurisdiction. Well, maybe not, but they want to freeze things in place while they're trying to figure it out. So yeah, maybe the court in the end doesn't have jurisdiction, but they're not quite ready to reach that conclusion yet. So they'd like to pause things while they spend a little time thinking about it. The All Writs Act does not provide an independent base for jurisdiction. That's true. I mean, that is 100% correct. The All Writs Act, like any writ, is just an act that a writ is just an order. And there are different kinds of writs and different kinds of orders a court can give. And the ability of the court to issue an order obviously depends on the fact the court has jurisdiction. And then, of course, your requirement to obey that act doesn't necessarily depend on jurisdiction, as we've discussed before, because if the court lacked jurisdiction to issue the order, you can appeal it, but you still might have to follow the order in the interim while that issue is being sorted out. Because jurisdiction sometimes is not necessarily 100% clear on some of these issues, particularly in some of these novel contexts about where jurisdiction does or does not lie. And we've already seen this, for example, as the United States Supreme Court had said, for example, with respect to illegal immigrants, that they couldn't file a habeas except in the jurisdiction where they were being held, which maybe wasn't necessarily clear previously, incidentally, because the courts are trying to figure out some of these issues as we go. because of some of these new contexts. So yeah, the All Writs Act is not a grant of jurisdiction. The All Writs Act just allows the court to issue an order, but of course it has to have jurisdiction to issue the order. I mean, that much I agree with. That's clear. Okay. The express terms of the All Writ Act confine the power of the court to issue process in the aid of issuing its jurisdiction. Cool. Therefore, the court had jurisdiction only if the court appeals had jurisdiction of the applicant's appeal, seeing 1254. True, right? Because the Supreme Court is the appellate review, so it only has review if the court below had review. And incidentally, we've seen this in other contexts, including the U.S. Supreme Court itself in merits decisions, saying for the first time no one had jurisdiction. We've seen that happen with subject matter jurisdiction or other kinds of jurisdiction. We've actually seen it happen where we've actually seen it happen where a case was filed and went through the district court on merits, went through the Court of Appeals on merits, went to the U.S. Supreme Court, and the Supreme Court's like, wait a second, no one actually had jurisdiction the entire time. Like a case that had been going on for like 8 years. And the Supreme Court says, well, no one actually had jurisdiction the entire time. And the entire case just goes poof, and it vanishes like it never happened. 8 years of frustration. But sure, I mean, yes, the Supreme Court only has jurisdiction in this context because it's a court of appeal. And the Court of Appeal only had jurisdiction if it had a valid basis of appeal. So fair enough. And the Court of Appeals had jurisdiction only if the supposed order the applicant's appealed amount to a denial of a preliminary injunction. That's true, because you can't appeal a TRO. And then what is or is not a TRO has been an issue that we've been seeing recently in the Supreme Court as well, about trying to determine what is or is not a TRO. Again, the label is not the thing. So just because the court calls it a TRO isn't necessarily a TRO. If it's real, you can only appeal a preliminary injunction. You can't appeal a TRO, but is it really a TRO? One of the issues that we've seen being discussed by some of the court decisions recently. But here, the order that applicants appealed was what they viewed as the district court's constructive denial of the request for a temporary restraining order. That is, the district court did not actually deny their most recent request for a TRO, but they inferred that it was constructively denied because the district court failed to rule on that request before the expiration of the truncated counsel-imposed deadline. Okay, maybe. I mean, what does it mean to deny a request? Or what does it mean to grant a request, right? So failure to act might be a denial within some time frames. I guess it's possible. So, yeah. The denial of a true TRO is not appealable. And here it's not clear the applicant's TRO request was actually denied. Fair. Indeed, in an order issued last night, the Fifth Circuit held it lacked jurisdiction for this reason. Okay, I mean, fair enough. So the Fifth Circuit thinks that it wasn't a TRO. Okay. All right. It's questionable whether the applicants complied with the general obligation to seek emergency injunctive relief in the district court before asking for such relief for the appellate court. You got to ask for it at the lower level first. When applicants request such relief in the district court, they insisted on ruling within 45 minutes on Good Friday afternoon, and when the district court did not act within 133 minutes, they filed a notice of appeal, which the district court held deprived of jurisdiction. It's doubtful if this aborted effort satisfies the federal rules of appellate procedure. Perfectly reasonable. Yeah, this is all procedural, but I appreciate that. Yeah, it's like, why can you insist on an order within 45 minutes? Why is a failure to act within 133 minutes mean that that's effectively a constructive denial? Now, maybe there's some facts here that they're not necessarily making clear about why that would be true. Maybe it's true that there were only, let's say, I don't know, 200 minutes. There were only 200 minutes in reality, or it would become moot. And so maybe this makes sense, but maybe it doesn't make sense. I mean, I appreciate that procedurally. When the court rushed to enter its order, the Court of Appeals was considering the issue of emergency relief, and they were informed the decision would be forthcoming. This court, however, refused to wait. Well, that's because someone appealed to them and tried to get the lower court, basically, I don't think that's a fair characterization, right? Because the Court of Appeals below is like, we're not quite sure. And then someone went to the US Supreme Court, is like, do you want to get involved? And the Supreme Court's like, yeah, we don't really want a piece of this either right now, but we will say keep everything in place or don't deport them until you hear back from us while we're figuring it out. And again, figuring it out in this context might be very short and might be very abbreviated, but I don't think that's a fair characterization of the situation. Even if the Supreme Court in the end feels, or even the Supreme Court in the end concludes that Alito is right, which maybe he is right in the end, I'm not sure I necessarily see the harm in the Supreme Court saying, okay, we want to take just a little bit longer to look at this. So even if the Supreme Court ultimately agrees with Alito on these issues, then I'm not sure I see necessarily the problem, but okay. This court, however, refused to wait, but under this court's rules, except in the most extraordinary circumstances, an application for a stay will not be entertained unless the relief was first sought in the appropriate court or courts below. I kind of think it was, to be honest, but okay. The only papers before this court were those submitted by applicants. The court had not ordered or received a response by the government regarding either the applicant's factual allegations or any of the legal issues presented, and the court did not have the benefit of the government response filed in any of the lower courts either. When the applicants first raised their allegation in district court, that court provided the government with 24 hours to respond and was poised to rule expeditiously. But district court dissolved the government's obligation to respond after counsel for applicant filed their hasty appeal, which in the district court's view deprived it of jurisdiction. Not for nothing, but I think one of the reasons that the Supreme Court is doing this is because they're feeling a little frustrated and a little jerked around. And they also think that the lower courts are been jerked around a little on some of this issue. So I think the Supreme Court is feeling disrespected. And they think the lower courts are being disrespected. And the courts don't really like that. They don't like to be disrespected. So I think one of the reasons the Supreme Court entered what could potentially be viewed as an extraordinary step of don't do anything until you hear back from us is because they're a little frustrated with some of the things that have happened in a way that have, been seen as really thumbing the nose at the court. So I think to the extent the Supreme Court is doing things they wouldn't normally do, I think that might be the reason why. 499 from Hamilton. Happy Easter, Kurt. I think you're an amazing person and very grateful for your show and wise and insightful analysis. Hi, Chad, as well. Thank you, and happy Easter to you as well. The papers before us, while alleging their applicants were in imminent danger of removal, provide little concrete support for the allegation. Yeah, but we've seen the federal government, we've seen the executive branch load people onto planes and try to spirit them out of the jurisdiction in a very hasty way. So while maybe the evidence as it relates to this particular case perhaps might be a bit thin, we've seen what you've done in other cases, and yeah, we're a little concerned. So yeah. Members of this court have repeatedly insisted that the All Writs Act injunction pending appeal may only be granted when, among other things, the legal rights at issue are indisputably clear, and even then sparingly and only in the most critical and exigent circumstances. Okay. Although this court did not hear directly from the government regarding any planned deportations under the Alien Enemies Act in this manner, an attorney representing the government in a different manner, JGG versus Trump, informed the district court in that case during the hearing yesterday there were no such deportations that were planned to occur either yesterday, April 18th, or today, April 19th. Yeah, but again, I'm feeling a little burned, and I think the Supreme Court is feeling a little burned because they've seen how the executive branch is dealing with these things. And it's like, even if you assume that's true, it's like, there's nothing planned for the 18th or 19th. Maybe we're not saying anything about the 20th at 12:01 a.m., right? It's like we're playing games. I think that's a lot of what's going on. Although the court provided class-wide relief, the district court never certified the class, and this court has never held that class relief may be sought in habeas. again, I think that that's probably true, but still an issue that needs to be resolved. And again, like, just can we put everything on pause while we figure it out because we're a little concerned? Yeah. Can you do a class in the habeas? I don't know. I don't know if you can do a class in the habeas or not. It certainly makes sense to some degree because these people are in large degree similarly situated. A class, by definition, basically what it is you have enough people that adjudicating them all individually just becomes inefficient. So for a class, you just need to basically have them all be sufficiently related in law and fact that you can adjudicate everyone's case all at once. It's an efficiency measure. So the question is, like, okay, even if it's people within like the Northern District of Texas, because habeas has to be filed there are a lot of people there. How many is a lot? I don't know, but enough to make it judicially efficient to combine them. So maybe it's 10 people. I don't know. But still, like, if the 10 people are related, then we can deal with it all in one breath. And so maybe you can do that. Maybe you can't do that. I don't know. Neither does the Supreme Court. The Supreme Court's never said you can do it. They never said you can't do it. And so, another issue that we have to resolve. But let's resolve it one piece at a time. In sum, literally in the middle of the night, the court issued an unprecedented and legally questionable relief without giving the lower courts a chance to rule, without hearing from the opposing party, within 8 hours of receiving the application, with dubious factual support of its order, and without providing any explanation for its order. I refused to join the court's order because we had no good reason to think that under the circumstances, issuing an order at midnight was necessary or appropriate. Both the executive and judiciary have an obligation to follow the law. The executive must proceed under the terms of this order, and the court should establish the following procedures. Yeah. So I understand Justice Alito and Justice Thomas's dissent. And so this is it. I think, at least in my humble opinion, it sort of boils down to, do you look at this case under its own terms, which is, certainly a fair way to do things. That's a lot of what we do in law. We look at cases under their own terms and under their own fact pattern, and we try to avoid bleeding cases over from one thing to another. But in the same breath, you can say also, we've seen how the Trump administration has loaded planes and tried to spirit them away out of the jurisdiction to deprive people of the court of jurisdiction. We've seen them behave in ways that are thumbing their nose at the court, defying court orders. We have an ongoing contempt proceeding in the DC circuit or DC trial court. We have ongoing issues relating to the Fifth Circuit. We've got relating issues to the Fourth Circuit. And we've seen the administration try to do things in a way that is, we've also seen them just be basically thumbing their nose at the court. So I think Justice Alito might be right insofar as this court, insofar as this case goes. So if you limit yourself to this case, I think Justice Alito is probably right. If you are a little bit more concerned because, well, it's not just this case, it's the immigration cases, and trying to treat them as distinct universes is perhaps not the best way of looking at it. Like, what is the right level of resolution is basically sort of what it boils down to. And we've seen how they've operated in other cases, and we're concerned that they're playing games and thumbing their nose. And so we're going to issue this relief, which again is fairly minor in scope. At least to me, it's really minor in scope, even if it's potentially a bit unclear, because these issues are percolating through the courts at an incredibly rapid pace. And so, like, what is the scope of the class? Perhaps a bit unclear. What is, can a TRO be appealed? A bit unclear. But the Supreme Court's saying, don't deport anyone until you hear back from us because we're a little concerned. I think on balance, I tend to agree with the 7-member majority, because it's like, I'm just a little concerned. And so I'm not really inclined to particularly trust you right now because of all these issues that are ongoing. So I see the case for both sides, but I think on balance, I'd be with the 7-member majority on this issue. Even if, of course, in the end, Justice Alito is right about these issues, which of course he might be. He might be right in the end that that there can't be a class habeas. He might be right in the end that the relief was extraordinary on its own time frame. He may be right in the end, but I still think putting a procedural clause while we try to figure it out on sort of the merits is the wiser course of action. $25 from Mandrake. I don't know. The lower court seriously started the disrespect. I don't agree. The government is being forced in their filings on these issues, and the Supreme Court has made their bed. Do you not think cutting out the stuff at the beginning, don't you think? Yeah, I don't agree. I don't see it that way. But I appreciate the super chat. I don't think the district courts are doing anything other than what they're supposed to be doing. And they may be wrong, but there's a process for review and procedure. So I just don't fundamentally agree. It is up to the judicial department to determine what the law is. The Alien Enemies Act is a law. It therefore has scope and boundaries and borders, whatever those scope, boundaries, and borders might be. The district courts are trying to interpret it, not for the least of reasons, that there's just not a lot of cases on it. You know, that we've invoked it, like 3 times? World War I, World War II, World War III, I think. And then maybe there's some stuff in the very early Republic dealing with it, but it's just not something that comes up a lot. So the district courts are trying to figure out what to do in this context, and they don't have a lot to work with. So to some degree, they're fumbling around a little bit because they're not sure. And I don't agree. Even if they're wrong, you know, then let's go through the Court of Appeals and, you know, try to figure it out one step at a time. But I just don't agree that the district courts are, you know, screwing around, or even if there are some district court decisions that could be viewed that way, I don't think it's true as a collective whole. I don't think that's correct. But thank you very much. District courts don't have jurisdiction? I disagree. District courts have to have jurisdiction with respect to at least the parties that appear in front of them, because that's where cases start. Almost every case starts at the district court level. So of course they have jurisdiction. The scope of their jurisdiction is disputable, and that's an issue that the Supreme Court is going to decide in another case yet to upcome with respect to the issue of birthright citizenship, but they're not really discussing birthright citizenship. What they're really discussing is the scope of injunctions. So at the moment, it's unclear whether or not they have jurisdiction. It's actually unclear. It may be true that they don't have jurisdiction, but at the moment, we're not sure, because the Supreme Court has never clarified it. And so it remains unclear. But thank you for your super chat. $5 from Mandrake. I don't believe judges are being genuine in their disagreement, but I respect your opinion. I can't speak to that. I just try to interpret things as best as I can, and I try to give my best opinion. And I at least to my mind, these are issues that are unclear because they are rarely invoked, and they've, to the extent they've ever been invoked, appear to have been invoked in times of actual declared war. And so the scope here is a bit unclear. But I don't necessarily agree with that, but I appreciate your super chat. Thank you. Let me see if there are any other member chats I want to respond to. What was the footnote? Sure, I can go back to the footnote. Give me a second. I don't normally read footnotes, but okay, it was an asterisk footnote. Interesting way of designating it. So the asterisk was, I'll read the sentence and then I'll read the thing. Although this court does not define putative class, it appears the court means all members of the class that the habeas petitioner sought to have certified, namely all non-citizens in custody in the Northern District of Texas who were or are or will be subject to the March 25th presidential proclamation entitled Invocation of the Alien Enemies Act regarding the invasion of the United States by Transde Agura and/or its implementation. And the footnote says, it appears the applicants have recently moved to amend their class for petition for habeas and their motions for class certification. So it's not clear if the applicants will continue to defend the specific definition or argue a new one. Yeah, so what is the class is also an issue that has to be figured out, which is also challenging in these times. Michael Stenson in chat says, my understanding is a TRO is meant to suspend action, not compel different action. It can be both, but typically preventing action is more typical, but that's typically true for injunctions, generally speaking. Injunctions tend to be more negative, like don't do things, rather than positive, do this. So yeah, I mean, that's true. If the court tries to compel the government to do something, it's not really a TRO. Well, I don't know that they were compelling. I don't think that's necessarily a fair characterization of the TRO. I think the TRO, although I could be mistaken, I don't know that it was requiring the court. I don't know that it was requiring the executive branch to do anything, but maybe I'm mistaken. I believe the TRO was basically effectively don't deport these people, but that's a don't, not a do. So I don't know that your characterization of it is correct, but fair enough. Happy Easter. Thank you. Michael says harm is the lower courts exceeding their authority and interfering with the executive branch illegally. Well, they may or may not be, but we're still trying to figure that out. The scope of the thing is unclear. All right, the scope of the thing is unclear for reasons I've stated. You think the lower courts are doing the jerking around? I don't agree. MI says, I think they should feel frustrated. The approach to the administration so far is ridiculous. Even if the objective is correct, that's not how you get things done. Yeah, I mean, again, like, yeah, we need to figure out exactly what this thing is. Atlas says the executive prior to the election and during the beginning of the term has been jerked around as well. They probably wouldn't have happened if Trump didn't experience the level of lawfare he did. Yeah, I don't disagree with you. There were a lot of things that were done to Trump that were wildly wrong by the previous executive. I agree. I agree. And some of those things were wrong, and a whole lot of things that were done to Trump were bad. And we should be absolutely critical of those things. But I don't think, therefore, we should say that somehow Trump gets a pass because bad things were done to him. Those bad things were bad. The cure for bad things isn't more bad things, basically. So, yeah, I mean, if you want to complain about how Trump has been treated by the previous executive or even by courts, I think that's fair to be critical of certain things. But I don't think that necessarily, therefore, should extend to us in this analysis. I don't think that bleeds over. $5 Australian from Greg. Trump administration shot themselves in the foot by ignoring the lower courts and due process. Yeah, I mean, to some degree, I think that's true. Yeah. The Trump administration has basically been trying to use the Alien Enemies Act as an express button. That's the reason they used it. And the courts so far have been like, not quite, like, slow your roll. They're still entitled to a hearing, even under the Alien Enemies Act. They're still entitled to a hearing, and they're still entitled to habeas. And also the scope of the Alien Enemies Act is still something that can itself be challenged within the scope of that proceeding as to whether the Alien Enemies Act applies at all. But yeah, I mean, the Trump administration was trying to do something in a way that, so far, not so much. So all that stuff. The big problem right now is everyone, courts and the executive branch, think that they're right. Well, I just try to go back to the Constitution, right? The Constitution, I'll say this again, like the president has no inherent authority when it comes to the issue of immigration, because Congress has the ability to set out the rules for immigration, the uniform rules for naturalization. So the president, when it comes to immigration, can only do what the Congress gave him the power to do. And those are laws, and those laws have to be understood and interpreted, because Congress wrote some things and they didn't write other things. So the law that Congress passed has scope. It must have scope. They wrote those words and not other words. They must have meant something by it. So the scope of the president is limited to the acts of Congress, including the Alien Enemies Act. Even the Alien Enemies Act has scope. It has words, and those words mean things. It doesn't mean everything. It means what it is. Now, those words can be broad. So they can be broad, but they don't necessarily, they still have scope, even if they're broad. So for me, I think that this is just an issue the courts are trying to work with, including what are the scope of some of these laws. And so what power does the president have? Because the president only has, with respect to immigration, such power as Congress gave him. He has no inherent power. So therefore, you have to go look to the acts of Congress and figure out what Congress gave him the power to do. And then he can do those things. And as I said, like with respect to the Alien Enemies Act, there's not a lot of cases on it. It's been invoked like 3 times, every time in a war. And when it was invoked, as memory serves, although I could be mistaken, I believe it was invoked for like basically a guy, or like, basically like one person that we were trying to get rid of. Maybe I'm mistaken on that, but I don't think it was broad in that sense. So this is broad both in the number of people it applies to, and it's broad in the sense that it's not during a declared war. And so there are still legal issues that need to be percolated. And the executive branch wants it to mean everything they want to mean, which is pretty typical. We've seen the executive do that a lot with a lot of things. We've seen a lot of administrations try to make this say the statute means anything I want to mean. This is why I can, for example, force people to take vaccination. This is why I can force vaccinations, because the law means anything I want to mean. It's like, no, it doesn't mean anything you want to mean. No, the CDC can't do this. No, you can't do, no, right? It's like, so yeah, but the executive branch often tries to, exert its power and take things to the wall. And the courts are there to stop that from happening. And they should stop it from happening, because like, no, the statute doesn't mean that. No, you can't force people to take the vaccine. CDC, you can't do that. That's not one of your powers. And so like in this context, to me, it's the same thing. It's like, okay, the president wants to deport people. Okay, cool. So he wants to deport people using the Alien Enemies Act. Okay, cool. All right, so what does that mean? And what's the scope of it? And the courts are trying to figure it out. And they're trying to figure it out as we speak. Again, like the Trump administration could just deport them because they're here illegally. That would be the simpler way to do this. He could just use standard deportation authority and it would make his life a lot simpler. But he was trying to look for an express button, and so far, not so much on the express button. So, that's where we're at. Is President Trump breaking any laws or the Constitution? At the moment, well, it's unclear whether he's breaking the laws. But to the extent that he's thumbing his nose at the judiciary, he's creating a constitutional crisis. If the courts say, you don't have power, or he's trying to like get outside the court's power, then it's creating constitutional crisis. So is Trump breaking the law? Don't know. And neither do the courts, incidentally. They don't even know whether or not he's breaking the law. They're still working on it. But it isn't the rocket express button that he thought it was, that's for sure. So, but the constitutional crisis is a bigger problem, because we're creating a situation where we have tension between the judiciary and the executive in ways that are creating problems. Michael says the AEA doesn't require only a declared war. It also requires an invasion or incursion. Yeah, I think that's totally right. I was just saying that we've never seen it in that context, right? That was my point. Like there's not a lot of case law. So you're correct. The AEA does not require only a declared war. An invasion or predatory incursion would also be fine. You are absolutely 100% correct. But of course, what does that mean is still an issue. Like, what does it mean to have an invasion? What does it mean to have a predatory incursion? What does that mean? And those mean something, right? What does that encompass? What does that mean? And so that issue still needs to be decided, and to the best of my knowledge has never been decided, because I don't think we've ever had an AEA case relating to that. Still working on that issue. But thank you for the clarification. You're not wrong. It's why borders should have been secured at all times. As to that, Hamilton, I 100% agree. Yeah, the previous administration opening the borders was dumb, irresponsible, and in degradation of their duty, and cynical, and a lot of other things. I 100% agree. Secure the border is fine. I have no problem with that. And he has done it, and he should do it. He should absolutely secure the border, and he has done it. He's reduced illegal immigration by like 99%. So it wasn't that hard. It could have been done the entire time. So it sounds like if Trump is successfully using the AEA as a rapid fire mechanism, it could be precedent setting. Yes, of course it is. Because whatever it means, it would mean for any president and any situation. So whatever the scope of the AEA is, then any president would be allowed to use it up to its scope. So ultimately, in the end, whatever the courts decide the AEA means, of course it's precedent setting. And then any president would be able to use the AEA in the same way. So yes. So ultimately, it will absolutely be precedent setting. Pierre says one of the biggest challenges isn't that the court sucks, is that Congress sucks and made both the asylum and immigration laws that make this quagmire. That may very well be true, Pierre. Maybe Congress sucks at its job, but it is the law they passed, and so what else can we do? Maybe get the law changed. Again, if you want to get the law changed, I'm happy with that too. That's fine by me. If you want to get Congress to pass some different laws and change things, that's cool too. That's political. Go do that. If they get the law changed, then cool. I'll be happy to interpret the new and exciting law as they amend it. That's fine by me. So if Congress says, this was dumb, let's do something different, totally fine. That's fine. What's the definition of an open border? Every single time I've crossed the border, I've had to show multiple forms of ID, been pulled in, and had my car searched. Yeah, but you went through a designated port of entry like a reasonable person. Yeah, you went through a designated port of entry. We're talking about people who did not come through a designated port of entry, and the government made no attempt to stop them. Yeah. Why can't securing all borders fall under the control of the Pentagon and its massive budget? I suppose it could, if you've passed a law to do that. Yeah, I mean, you have the issue right now of posse comitatus, but posse comitatus is just a law. You could amend it. So if you think that immigration issues should be done by the Pentagon, no problem. You can get that done. Yeah, just transfer immigration to Pentagon, repeal posse comitatus, to the extent you need to, and call it a day. And Bob's your uncle. No problem. You can do that. I don't even necessarily have a problem with that in principle, incidentally, because the military securing borders is a common thing the military does. So the military is going to secure the border and prevent people from coming in illegally. That's pretty common in the world. So the idea that the military should be doing this, not exactly unheard of in world affairs. Have the military guard the border and have them, that makes sense to me. Yeah, amend the law, no problem. 499 from Michael Lawless. Will Chevron start coming into play? Chevron is dead. Thank God. Chevron is dead. Chevron is dead. We used poisonous gases and we poisoned its asses. Chevron is dead. Chevron is dead. Chevron is dead. Chevron is dead. These poisonous gases and we poisoned its asses. The Chevron is dead. Okay, or is it all con law executive powers? I know alien MAs is its own thing. Well, it's a lot of con law, that's for sure. Yeah. Yeah, the Trump immigration ban took 3 attempts, right? Yeah, exactly. When Scott shot down Biden, he tried our laws. Yeah, so yeah, when it came to Biden trying to do student loan forgiveness, he was kind of trying to do the same thing that Trump was kind of trying to do when it came to the immigration ban, because it took 3 tries. And so Biden was like, okay, this didn't work. Let me try a different way of doing it. And whether or not any of those would have been ultimately successful, who could have say? But okay, I didn't have authority for this reason. Let me try authority for this reason. Yeah, we've seen presidents do that before. Just Rhonda says, I feel like the last 4 years have been an invasion. I'm not a border state, but close enough for illegal aliens to get here just as easily. I appreciate that. I'm not sure it's an invasion within the meaning of the Alien Enemies Act, but it's something, and I appreciate that. All right, guys. Well, I guess that will end our stream for today because I see nothing else in chat. But we will see if there's anything else for us to respond to and maybe have other videos today. And then later today, I'm going to play kickball because I want to go run around for a while and burn some calories. That'd be fun. But let's see if there's anything else I want to cover that looks good on the docket that looks interesting. The DC Circuit stayed the criminal contempt proceedings. Interesting. Late yesterday, this is on the 19th, so this is the day before yesterday, so on the 18th. Late on the 18th, the motions panel for the U.S. Court of Appeals for DC Circuit issued an administrative stay delaying criminal contempt proceedings against the Trump administration. The stay was imposed by a majority of the panel. The order gives the panel more time to consider the administration's order. The order, therefore, from the Court of Appeals for DC Circuit reads, upon consideration of the emergency motion for a stay pending appeal, or in the alternative, writ of mandamus, it's ordered that the court ordered on the court's own motion that the district court contempt-related order entered on April the 16th be administratively stayed, pending further order. The purpose of the stay is to give the court sufficient opportunity to consider the emergency motion for stay or the writ of mandamus, which should not be construed as a ruling. So again, they want to put things on pause while they take a little bit more. And then they ordered more hearings relating to that. I appreciate my addressing comments, even though they're not connected to a super chat. Yeah, well, I'm only limiting myself to member chats, at least at the moment, but, you know, I want to respond to as many chats as I can. So as per policy I previously expressed, I'm limiting myself to super chat and members chats for my own sanity. But it is, after all, only 99 cents a month to join. So if you want to join, and that policy is only on the more controversial streams, so I can maintain my sanity. And it is working relatively well, I think, as well. If I can't see it, I don't respond to it. And then my sanity is preserved. It's nice. All right, I don't see anything else at the moment. Let's see if there's anything else on the Court of Appeals level that looks interesting. All right, man buys New York City house in 2014. When he goes to sell it in 2021, he discovers for the first time a $1,000 penalty from the city for failing to report about a boiler that had been removed before he bought the house. The city, a third party's contractor, mailed the violations in 2015, so he probably got it then and should have filed several suits years ago. The man, I did not get it. The Second Circuit, good enough for government work. Well, a Fourth Circuit judge-on-judge bench slap. Those can be fun. It stems from a man's guilty plea for robbing a gas station and his plea appeal waiver. Rather than explain what the waiver meant, detail its scope or exceptions, and probe to see if the man understood what he was waiving, the district court decided 12 years of his life in 13 minutes. This is the regular practice of the district court, knowing it's generally shielded by appeal waivers, and it's a miscarriage of justice that cannot remain unaddressed. The man gets a new sentencing in front of a new judge. Ooh, Fourth Circuit wants to beat around a district court for a while. That sounds fun. Maybe we'll do that later today. Prisoners allege repeated abuse from a prison officer. He files a complaint with Bivens' claim against several individuals, but separately files a complaint against the U.S. He loses in both cases, but only appeals to Bivens. The Fourth Circuit, oops. The loss means there's a judgment bar on the Bivens claim. Ouch. That was a mistake. A man bills a pharmacy focusing on compounded drugs. Kickback involving federally reimbursed drugs are illegal. To avoid tripping that wire, the man restructured his business and converted those marketing drugs from independent contractors to W-2 employees. Marketers continue to offer incentives to physicians to write prescriptions, and the marketers receive commission tied to the prescription's value. The jury, that's a kickback. The Fifth Circuit, conviction and sentence affirmed, including $60 million in restitution. Ouch. Officers in Laredo, Texas chase a driver for 2 hours, spike his tires, and box him in, at which point he rams into one of the cruisers. Over the next 10 seconds, officers fire 9 rounds, 3 as the trunk lurches forward, 3 more as the engine stops revving, and 3 immediately after. One of the bullets paralyzes the driver. District Court says the officers have qualified immunity for shots 1 to 3, but not 4 to 9. The Fifth Circuit, officers reasonably believe they were still under a threat from the 5,000-pound weapon when they fired 4 shots 4 to 9. Qualified immunity for the entire volley. Yeah, I'm not going to, that sounds fine. I mean, give me a break, right? Shots 1 to 3, qualified immunity, but not 4 to 9. Come on. Even under a qualified immunity decision, give me a break, So a dentist writes 2 hefty morphine scripts after an 8-hour dental procedure. The patient tragically ODs and her blood test comes back triple for the fatal amount. The jury finds the dentist knowingly issued an illegal prescription. He's convicted and faces a 20-year sentence. The dentist appeals, arguing the jury wrongly heard testimony about earlier forged prescriptions and profanity-laced firings. The Sixth Circuit, yes, that's classic Rule 404B, character not intrinsic, thus new trial. An Ohio cop pulls over a car and sees a marijuana residue inside. How you can identify marijuana residue by sight, I'm not quite sure, but let's press on. The driver, who's a convicted felon, claims he has a state-level medical marijuana license. A search reveals firearms. Was the search okay because pot is still illegal under federal law? Sixth Circuit, damn right it was. Even though Congress has told federal officers they can't enforce federal marijuana law when the pot is legal under state law, it's perfectly fine if the state officers enforce that federal law, even if they can't under state law. So, yeah, that makes sense to us. Head down to sunny Florida for the 11th Circuit extremely readable explication of the Court of Supreme Court cases that govern sentencing of juvenile offenders. The law, simplistically, is that sentencers have to consider youth in one way or another depending on the crime. The 11th Circuit, and approximately 170 juvenile lifers. Sentencing authorities in Florida do consider youth. They might be super stringy about it, but the system's not a sham, and that's all the Eighth Amendment requires. They say the best way to stop a bad guy with a gun is a good guy with a gun. Unless that is, if a cop shoots and kills a good guy with a gun because the cop thinks that the bad guy with a gun, does that make the cop liable to the good guy's family? The 11th Circuit, look, accidents happen. Yeah, if you are in fact a good guy with a gun, but the cop, based on his observation, thinks you might be the bad guy and shoots you, that just sucks for you. Yeah, that just sucks for you. That's not great, but that's right. All right, so I think maybe later we'll do the bench slap because that sounds fun. So maybe later today we'll do the Fourth Circuit yelling at a district judge for being dumb because that sounds fun. Maybe we'll do it sooner rather than later because I want to do kickball this afternoon. So maybe I'll take an hour break and come back and we'll do this stupid for a while. So tune in for that because it sounds like fun. All right. All right, guys, I'm going to sign up for now. I hope all is well. Your guys, great. Don't forget, on Tuesday, we're going to be starting Karen Reed coverage. It's going to be basically all Karen Reed all the time for like 6 weeks straight. Could be entertaining, could be fun, could be frustrating, could be a lot of things. But, tune in for that. Until later, I've been Uncivil Law. Hope you have a great one. I'll see you maybe in about an hour or so. Until later, my friends. Peace and goodbye.